In the previous section, you learned about the various forms of co-ownership, including tenancy by the entireties, community property, and partnership ownership. Now we move into the world of trusts and estate planning, which play a vital role in how property ownership and transfer are managed beyond a person's lifetime. These tools, living trusts, land trusts, and wills, allow individuals to maintain control over their assets, reduce taxes, and avoid the time-consuming process of probate. Living trust. A living trust is one of the most effective estate planning instruments for managing property during a person's lifetime and transferring it efficiently after death. In this arrangement, the trustor, the person creating the trust, transfers assets to a trustee who manages them for the benefit of one or more beneficiaries. The trustee has a fiduciary duty, meaning they must act in the best interest of the beneficiaries, maintaining and managing the assets responsibly. Most living trusts are established as revocable trusts, which means that the trustor can modify or dissolve the trust at any time during their lifetime. This flexibility allows the trustor to adjust beneficiaries, add new assets, or change the terms if their personal or financial situation changes. For example, a parent might create a living trust before their first child is born and later amend it to include additional children as beneficiaries. An irrevocable trust, by contrast, cannot be changed once it has been established. While this may seem restrictive, irrevocable trust can provide tax advantages and greater protection from creditors. However, both revocable and irrevocable trusts remain subject to estate tax upon the death of the trustor. The primary advantages of a living trust include avoiding probate, maintaining privacy, and ensuring that property is distributed according to the grantor's wishes without court intervention. Unlike a will, which becomes public record through probate, a trust allows assets to be transferred privately. Additionally, living trusts can specify how and when beneficiaries receive property. For example, a parent might require that a child reach a certain age or milestone, such as completing college, before receiving a distribution. Land trust. A land trust is a specialized form of trust used exclusively for real estate. In a land trust, the trustor transfers the title of a property to a trustee, who holds it for the benefit of a beneficiary. Uniquely, the trustor can also serve as the beneficiary, retaining control over how the property is used and sold while keeping their identity confidential. The trust agreement, also known as a deed in trust, outlines the trustee's duties and powers. While the trustee holds legal title, they cannot act without the beneficiary's approval. This structure provides several advantages. The beneficiary controls the property, including its use, occupancy, and sale proceeds, while the trustee performs administrative duties such as maintaining title and executing deeds. One key feature of land trusts is privacy. The beneficiary's name does not appear in public records, meaning ownership remains confidential. This is particularly useful for investors, developers, or public figures who prefer anonymity. Additionally, the beneficial interest in a land trust is considered personal property, not real property. This classification makes transferring ownership easier. It can be done by assignment rather than by recording a new deed. There are additional benefits as well. Because the beneficial interest is personal property, it can be pledged as collateral for loans without requiring a recorded mortgage. It also simplifies probate since the property is probated in the state of the beneficiary's residence rather than where the property itself is located. However, land trusts have a limited lifespan, typically ranging from 20 to 30 years. When the trust term expires, it must be renewed or the property will be sold and proceeds distributed to the beneficiaries. Probate and wills. Even with the advantages of trusts, many estates still involve a will, a foundational legal document that directs how property should be distributed upon death. A will serves as an instruction manual for the court-supervised process known as probate, where the estate is evaluated, debts and taxes are paid, and remaining assets are distributed to heirs or beneficiaries. To be legally valid, a will must meet certain requirements. The testator, the person making the will, must Be at least 18 years of age. Be of sound mind and acting voluntarily. Clearly intend to create the document as a will. Sign the document along with 2 witnesses in accordance with state law. The will typically names an executor, the person responsible for managing the estate, paying debts, and distributing property. If the testator has minor children, the will should also appoint a guardian to care for them. Additionally, the will can establish a trust for minor beneficiaries to ensure responsible management of their inheritance until they reach a specified age. For example, Grandma Betty, who lived a long and fulfilling life, created a will to ensure her estate was distributed fairly and her beloved cat, Whiskers, was cared for after her death. Because her will met all legal requirements, it was validated in probate, and her executor could follow her instructions exactly as she intended. Changing a will can be changed or revoked at any time while the testator is still alive. The simplest way to make a change is to revoke the existing will and create a new one. All old copies should be destroyed to prevent confusion after death. Alternatively, the testator can use a codicil, a written amendment that adds or modifies specific provisions of the original will. However, codicils can complicate matters if too many changes are made, so writing a new will is often cleaner and more effective. Because probate and estate laws vary from state to state, it's always wise to consult a qualified estate attorney when drafting or revising a will. Review summary. A living trust allows property owners to manage and distribute their assets during their lifetime while avoiding probate and maintaining privacy. It can be revocable or irrevocable and provides flexibility in estate planning. A land trust focuses on real property and allows the truster to remain anonymous while retaining control as beneficiary. The beneficiary's interest is considered personal property, simplifying transfers and protecting privacy. A will, on the other hand, serves as a legal document that directs asset distribution upon death, requiring probate for execution, but providing clarity, guardianship designations, and control over estate matters. Discussion. Why might someone choose to create a living trust instead of relying solely on a will? Answer. A living trust avoids probate, maintains privacy, and allows for ongoing management of assets during the truster's lifetime. What makes a land trust different from a traditional living trust? Answer. A land trust is limited to real property, allows the truster to remain the beneficiary, and keeps the beneficiary's identity confidential in public records. What are the legal requirements for a valid will? Answer. The testator must be of legal age, of sound mind, acting voluntarily, and must sign the will with witnesses as required by state law. How can a will be changed or revoked? Answer. It can be revoked and replaced with a new will, or modified through codicils that formally amend specific sections. Closing remarks. Trusts and wills are the foundation of estate planning. They allow individuals to maintain control of their assets, protect their families, and ensure their wishes are carried out efficiently and privately. Living trusts streamline asset distribution and avoid probate. Land trusts preserve privacy for property owners, and wills provide legal clarity and direction for final affairs. Real estate professionals should understand these instruments to better guide clients through ownership and succession decisions, always reminding them to consult legal and tax experts before making binding estate choices.